Hello and welcome to the Rogers Brief for January 13th, 2023, Friday the 13th. I hope people are not superstitious about this sort of thing. I'm Adam Rogers. Thank you for watching and thank you for listening if you're catching this on Apple or Spotify podcasts. I do these videos on a weekly basis and I cover issues that are in the news that have either a legal angle as their primary feature or else maybe a legal angle that's underappreciated, and I think I can explain from a lawyer's perspective to a general audience. And so I hope people enjoy the content. If you do, please like the videos, subscribe, share it with a friend. All of that helps spread the message. And so if it grows the audience, which I'm trying to do, so that's great. I appreciate your help in doing so. This week I'm going to be covering mostly Nova Scotia cases, including the tragic death of Alison Holtoff at the Cumberland Regional Health Centre, which took place on December 31st. It's been in the news this week because of a controversy over a letter that her local MLA, Elizabeth Smith-McCrossin, wrote and published on her Facebook page on January 6th, and the reaction from the Nova Scotia Department of Justice to that situation. So I'm going to cover that as a clumsy attempt by the Department of Justice, I thought, to try to silence MLA Smith-McCrossin, and that hasn't worked, and rightfully so. So I'm going to talk about that and some of the legal angles associated with that. There's a few other Nova Scotia cases as well, one involving a military veteran in Lunenburg who was improperly tasered back in 2016. And that case has finally come to a decision of the Civilian Review and Complaints Commission, the commission that overlooks the RCMP. So I'll talk about that. I'm going to talk about a couple of fisheries cases. They're not related in a sense of the people, but they are related in terms of their content, both dealing with the Indigenous fishery, First Nations, ceremonial food and social fishing licenses for lobster fishing. And so there's two decisions coming down this week on that are related, and I think indicate some of the problems that are out there on the water, and some things that are real serious and need to be addressed by the Department of Fisheries. I'm going to talk about a charter case out of Sydney involving a lady who was charged with quite serious crimes back in 2018, but have had those charges stayed by the court because of a delay caused by the Crown Office and the Cape Breton Regional Police. I'm going to talk, I'll talk about the William Sanderson retrial. Mr. Sanderson was convicted of murdering Taylor Sampson. He was convicted in 2017 of the murder which took place in 2015, successfully appealed it in 2020, and is now back for a retrial. So I'll talk about that and what I expect will take place there. I'll talk about Alison Holtoff and that situation with the allegations of privacy violations from the Department of Justice. And then finally I'm going to wrap up with, those are all Nova Scotia cases, of course, and I'm going to wrap up revisiting a discussion I had last week about the Jordan Peterson versus the Ontario College of Psychologists professional disciplinary situation that they have going on there. So some very bizarre, curious at least parts of their complaints process, which I think are going to really favor Dr. Peterson. So I'll finish with that. So I'll start off with a couple of some of the shorter stories in a sense. This RCMP, the RCMP is disputing this decision from the Civilian Review and Complaints Commission, and dealing with Bruce Webb, who's a Canadian Armed Forces veteran who has a medical implant. But he was tasered. He was tasered in his residence back in February of 2016 in Lunenburg. Now, by Constable Mark Thomas of the RCMP. There were two other officers present. They had gone to investigate a noise complaint, and the Civilian Review and Complaints Commission goes, they make a point of saying that Bruce Webb was no angel. He was, being persistent in inflicting this noise on others. He had no license to do so. He was operating a lounge sort of without a license, and so there was some other issues there that he was facing on a civil basis, I guess. Not civil in the sense of he was being personally civil, but I mean a non-criminal basis. Operating operating a lounge without a license isn't the most serious thing a person could be doing. Anyway, so the police went to investigate the noise complaint. He wouldn't let them in. Webb wouldn't let them in, so they took down the door, and then they tackled him. He was on his rear end on the floor, and not able. He wasn't being aggressive or anything like that, but he was resisting their efforts, I guess. So Constable Thomas took out his taser. Webb said, "Don't do that. I could die." And anyway, they tasered him anyway. Webb fell sideways to the floor and needed medical attention, needed to have his implant fixed over the coming months, and was living with great pain for a while as well. So what the Civilian Review and Complaints Commission determined was that this was all unjustified, that the warrantless entry itself was unjustified, and that it was a premature use of a taser, that the officers had made no attempt to de-escalate the situation. So really it's a problem. It's a problem for that reason, just on the substance of it in itself, but also the problem is procedural, which is that the Civilian Review and Complaints Commission really doesn't have much in the way of teeth. I mean, we learned this a little bit during the Mass Casualty Commission. Police oversight is really lacking in terms of the ability to, enforce this or have any consequences flow from, improper police behavior. There's, nothing binding that will come out of this. There may be recommendations, but the RCMP is disputing them, and so what's likely to happen is that they'll just go on. Everybody will go on. No criminal charges against Mr. Webb. Those have been withdrawn. No civil claim by Mr. Webb. A little surprised by that. He would certainly have a civil claim based on what we're reading here. But it's too late for that to start now. There's a time limitation on starting that, and the incident was from 2016. So anyway, that's just another example of improper police behavior. Those that follow this channel would know that I'm attuned to that. So I just wanted to raise that as the first story. Next one. These are two cases that came out this week, and they were unconnected but related. And they were both reported by Paul Withers from CBC News. One was provincial court judge Tim Landry dismissed charges against 3 fishermen from the Sebeganegati Band. That was James Wallace Nevin, Leon Knockwood, and Logan Piero Howe. They had landed 602 kilograms of lobster at the Weymouth Wharf back in 2018. And the Crown was alleging that was in excess of their 40 kilograms per day limit that 2 of the fishermen had as their food, social, and ceremonial licenses. So the defense, on the other hand, was claiming that they had a treaty right to fish and that the 40 kilogram daily limit was not a legitimate limit that was imposed by the Department of Fisheries without proper consultation, without proper consideration of the Marshall decision of the treaty right to fish, and so on. So the potential there for an interesting analysis and decision, but in fact the judge didn't really confront those issues head on, but it rather said, well, it was a real technicality. He said the Crown didn't bring in evidence that these fishermen didn't have some other license, a regular lobster license through the Department of Fisheries, and so therefore found them not guilty and dismissed the charges. So the fishermen, of course, are very happy about this and saying, well, this is great, this is going to benefit everybody, but no. First of all, that wasn't even argued by the defense. And for any future case, all the Crown would need to do is bring in someone from the Department of Fisheries, or even just file an affidavit from the Department of Fisheries saying, we've searched this name, there is no license in our system for this person, and therefore, it's either the food, social, and ceremonial license or nothing. So there's really not much in terms of precedent value in that regard. Plus, I would suspect that this case will likely be appealed to the Supreme Court, and so maybe a judge at another level will directly face the issues that the judge at the provincial court didn't want to. But it's indicative of what's out there and what's in dispute. So this 40 kilograms per day food, social, and ceremonial license, if the First Nations fishermen are not seeing this as a legitimate limit or a legitimate regulation, then that's a problem, because that means they'll be out there fishing without feeling subject to any regulation, perhaps. So that's one thing. The flip side of that was a case out of Sydney, which was Bernard McIntyre, who pled guilty to cutting lobster traps from the Member 2 band. And these were lobster traps that were set in December of 2020, December 3rd, 2020. And there was a big uproar at the time. There were 60 people at the wharf estimated 60 people at the wharf in North Sydney across the harbour, and 30 or 40 vehicles. When Mr. McIntyre cut the traps, he went back to North Sydney, where he had which he had departed, and the fisheries officers wouldn't even follow him back to the wharf. They were afraid of escalating the situation and potential for violence, so they didn't even go back to North Sydney with Mr. McIntyre, but they found him and they charged him at a later time. He pled guilty. He was fined $6,200, which is a significant fine, and he was ordered off the water for 6 months. Now, those 6 months will cover the time of the Member 2 food, social, and ceremonial license fishing time, but not Mr. McIntyre's own fishing season, lobster fishing season at least. So he was charged with cutting the lobster traps, plus with ignoring the DFO officers. And so anyway, the prosecution in their sentencing remarks said that one of the reasons that they prosecuted this case was to show support for the food, social, and ceremonial license system and the license holders. But I guess it sounds like neither side, if you can call them sides, I mean, they're not, I'm sure these aren't airtight compartments, but neither the traditional fishing community, well, I don't even want to put it that way, the existing DFO license holders don't seem to see this as a legitimate development in the fishery. The First Nations fishermen don't seem to view the 40 kilograms per day as a legitimate limit. So I think more work needs to be done there on that issue as a whole, or else we're just going to see more conflict on the water and on the wharves, and nobody wants that, certainly. All right, next story. Staying with Sydney, actually, in the Sydney same building, different level of court, though. This was a decision from Justice Robin Gogan of the Supreme Court of Nova Scotia out of Sydney, and it was a case involving Willow Burkhart, who was charged in October of 2018 with, after a motor vehicle accident in Cox Heath, with impaired driving and with dangerous driving causing bodily harm. Now, the trial was to have started on December 5th of 2022, and that's a 49-month, 12-day delay from the date of the charge. And so Ms. Burkhart raised the issue of delay in her charter rights under Section 11B, the right to be tried within a reasonable time. Now, there were disclosure issues throughout that caused the delay, and these were all on the side of the Crown. Now, Ms. Burkhart did change lawyers at one point, but that really wasn't the cause for much delay. The court assigned 47 of the 49 months to the Crown and the police as being their fault for the delay. Disclosure issues over the 911 call and photos, blood samples, and expert reports that were going to come in. The CVs or the resumes for the experts hadn't been properly disclosed or disclosed in a timely way. So there were all kinds of issues that really revealed systemic problems, I think, with the Crown Office there, plus the police, or some combination of the two. But I guess what I was really looking for in this case was any discussion about the pandemic and how the blame for the delay might be attributed to the pandemic itself. Well, Justice Gogan talked about the pandemic, but what she said was, well, if there's going to be blame given to the pandemic for delay, it needs to be, we can't just say it's, like everybody does for everything now, oh, well, the pandemic and therefore the delay, and without really an explanation. There needs to be something specific to this particular case that shows that the pandemic caused it. Like there was court dates scheduled, but they got delayed because the court was on, different protocols at that time or whatever. So none of that was the case here. The pandemic didn't cause the delay. There was nothing specific causation-wise, and so the delay was unreasonable. Now, the Supreme Court of Canada a few years ago in a case called Jordan, anybody that's in the court system will probably be familiar with this court case now, because the Jordan decision set limits. So if it's in provincial court, if it's a summary conviction matter, your case has to be heard within 18 months. If it's going to Supreme Court, an indictable matter, then it's 30 months. Now the time frame, it's not a hard and fast rule because it depends whose fault it is. If it's the defendant's fault, if they've changed lawyers, if they've adjourned, if they're not ready, or all these things, that whatever's the fault of the defendant doesn't count. But if it's the fault of the Crown, the police, or the courts, then if you get to 30 months, then presumptively you're out of time and the charges get withdrawn. These were serious charges, dangerous driving causing bodily harm, impaired driving involved as an allegation. So some serious charges being withdrawn because of delay on fairly simple matters of disclosure from the Crown Office to defense. So that was the decision there. I thought that would be of interest. All right, next story. William Sanderson's retrial. Now, William Sanderson, like I say, was convicted of the murder of Taylor Sampson. He was convicted in 2017 of the murder which occurred August of 2015, at which time Mr. Sanderson was just about to enter Dalhousie Medical School, or just about to start Dalhousie Medical School. He was convicted in 2017 of the murder of Taylor Sampson, who was a physics student, I believe, at Dalhousie as well, and convicted in 2017, appealed it, and was successfully appealed it in 2020. Now, the allegations were that these two individuals were both involved in the marijuana drug trade, and this was a fairly large deal of 9 kilograms of marijuana. This is the allegation from the Crown side, that Mr. Sampson brought to Mr. Sanderson's apartment to be exchanged for $40,000. Sanderson allegedly shot Sampson at that time in his apartment. Allegedly, the neighboring apartment dwellers heard the shot, that Sanderson then disposed of the body, which has never been found, took it out of his apartment in black plastic garbage bags, put it in his trunk of his car, drove to a farm property that his family had in their Truro area, and disposed of it there. Although, like I said, the body's never been found. But DNA from Sampson was found in the apartment, in the trunk of the car, and at the farm itself. So there's some connections there. There's also some text messages that the RCMP have they were shown by Sanderson. Not sure why he showed them these text messages. But, the text messages showed that they were supposed to meet the night of, in August of 2015. But Sanderson suggests that the text messages showed that they, in fact, never met. But it's him sending, Sanderson, that is, sending text messages to Sampson. So there's a possibility that they're self-serving and just done to throw anybody off the scent that might have actually seen the text messages. In any event, the successful appeal wasn't on any factual matter, but it was on a trial fairness issue. And the issue was that Sanderson had hired a private investigator to help him out, but then the private investigator turned around, had interviewed some witnesses, spoke to a police officer at one point and said, look, you guys haven't really investigated this very well. Look what I've found. And turned over some of the information to the police, who then used that to interview the witnesses, get more information, and use that against Sanderson. So, and that was only revealed to Sanderson and his lawyer during the trial. So the trial judge thought that that could be fixed with an instruction to the jury at the time to, think about it, and a little bit of a delay to allow Sanderson's lawyer time to consider cross-examination, issues and how that was going to be handled. But Court of Appeal said no, that's a trial fairness issue. He needs to be sent back for retrial. Now, often when that's the case and the Court of Appeal sends something back for retrial, if it's a substantive issue or if there's just been a long time or, the trial or the charges aren't particularly serious, the Crown won't bother going ahead with the retrial. This case, they certainly are. It's a jury trial again. They started this week, and so they're going ahead with it. I suspect, that the same evidence will be brought in. Doesn't seem to be anything really missing. No witnesses have died in the meantime or anything serious like that. So I suspect Sanderson will be convicted again, and hopefully there's no procedural issues that keep that from happening as it should, I guess, if that's what should happen. Of course, he's again presumed innocent during this entire time, but it sounds like there's a considerable amount of evidence against him. Now, the jury it was a jury trial. They started out with 14, they lost 1. Not unusual to start out with more than 12 jurors, although ultimately when it gets down to the deliberation stage, now there's 13 jurors. One of those jurors will be dismissed, and the other 12 will be the ones who deliberate. So somebody will be sitting through this trial for, no reason in a sense. All right, so that's the William Sanderson retrial that started this week. We'll follow that along as it'll probably continue, I think, next week into and maybe beyond that. Jury trials tend to take a lot longer than just judge-alone trials. All right, next story. This was a big one from Nova Scotia this week. This is the Department of Justice's reaction to the death of 37-year-old mother of 3, Alison Holtoff, which took place, like I said, at the Cumberland Regional Health Centre on December 31st, 2022. Ms. Holtoff and her husband Gunther had spent 6 hours waiting in the emergency room waiting area. When she finally got treated, there was some medical intervention, but it was too late, and so Gunther Holtoff was concerned about this, went to speak to a number of people, including his MLA, Elizabeth Smith-McCrossin, the MLA for Cumberland North, independent MLA, formerly a progressive conservative MLA, but is now independent. And Miss MLA Smith-McCrossin wrote a letter to the health minister about the situation, saying this should be reviewed, and then posted the letter to Facebook, to her Facebook page. That was on January 6th, which was last Friday. Friday night, close to midnight on Friday night, Michelle Higgins, who is the Executive Director of Legal Services for the Department of Justice in Nova Scotia, so one of the top Department of Justice officials, sent an email to Elizabeth Smith-McCrossin saying, you're disclosing people's private health information. You should consider taking that down, and if you don't, we'll be reviewing legal options against you. So Elizabeth Smith-McCrossin rightly did not take the letter down, and in fact, rightly, I guess, publicized the fact that she had been threatened in this manner. The references in the letter, we haven't seen the actual email, from Michelle Higgins, but what we understand from media reports is that the references were made to the Personal Health Information Act and the Freedom of Information and Protection of Privacy Act, both pieces of privacy legislation in Nova Scotia. But there's a number of problems with that. First, the information was already public. The only information that was published was Ms. Holtoff's name, her age, the fact that she was a mother of 3, and the date that she died, all of which was available otherwise in the obituary and wasn't particularly private anyway. But the main part is Elizabeth Smith-McCrossin's an MLA. The legislation doesn't apply to MLAs. It is meant to protect citizens from the government. It's meant not the other way around. It's meant to protect citizens from having their information disclosed by the government or by health officials, anybody in the health system disclosing your information. They're supposed to keep it private. It's to protect private individuals, not to protect the government from unwanted bad publicity. So Anyway, I'm sure there'll be more digging into this. Who authorized the letter from a very high up official in the Department of Justice? It seemed to be, and I know Elizabeth Smith-McCrossin presumed it to be, a political attempt to silence her with that legal threat. Certainly, the government would know the power of such a health story, an individual health story. Now, Elizabeth Smith-McCrossin told Sheldon McLeod in an interview that she, being that she is an independent MLA, is not as vulnerable or susceptible to the kind of pressures as others might be. And so she was wondering, are other MLAs being silenced in the same manner and maybe, being more susceptible to it because they face different pressures than she does as an independent MLA? She likely has a good point there. Anyway, the Department of Justice has now said that they will be taking no action. That they now realize that Gunther Holthoff had approved of it himself. Now, there is a slight there's a slight issue here, which is people who, even after you're dead, you still have privacy rights to your private health information. There is still some protections there, but not in cases like this. Elizabeth Smith-McCrossin did the right thing. There's a public interest in knowing about these kinds of deaths, and she brought that to public attention, and it was entirely correct that she do so. So glad that that threat was removed. Certainly, though, there should be that should be addressed by the Department of Justice or by somebody at least. That's completely improper that kind of pressure be sent off and an attempt to silence an MLA like that be made. All right, I'm sure we'll be hearing more about that one. Final story, Jordan Peterson. I was following this just because it's in the news and it's just something else. So last week I talked about the Ontario College of Psychologists, and Jordan Peterson is a clinical psychologist. He can see clients, although he doesn't anymore. But they have, a professional oversight body, the same as the, teachers, lawyers, doctors, other professions do. And so there was some complaints made about social media posts that the Dr. Peterson had made, his appearance on a Joe Rogan podcast, and some other comments. So this week we got more details about, of course, Jordan Peterson has, he was told by the college that he had to undergo a social media training program. He had to pay for it, and it was going to be, an uncertain timeline, which would only end when the instructor felt that it was time that he had learned his lesson. Well, of course, Jordan Peterson wasn't going to agree to that, and he didn't. So now we see the decision. It's out online. But the interesting part is the way that the complaints were issued. Okay, so here's this timeline. January 27th, there was an email to the college about Jordan Peterson's some tweets on COVID. Okay. And then so the college wrote the person back by email and said, hey, are you trying to make a complaint here against Dr. Peterson? And there was no response. So there you go. That should have been that. The next one was February 4th. And there was a report made about Jordan Peterson on the Joe Rogan podcast. And some of the comments he made there. Well, it's a 4-hour podcast. Joe Rogan's podcast is the most popular one in the world. But nothing really terribly specific about his comments on the podcast. Just sort of, here's a copy of the podcast. We don't think this is right. The next one was not even a report or a letter or an email, but just somebody tweeted to the college with a copy of one of Jordan Peterson's tweets, just saying, hey, what about this? The next one was February 9th, an anonymous caller, again talking about Jordan Peterson's tweets and the Joe Rogan podcast. February 22nd, another tweet to the Ontario College of Psychologists. And this was regarding, copying tweets that Jordan Peterson had made about Jacinta Ardern and how in Canada there's no real culture of Nazism and white supremacy. That was Jordan Peterson's opinion in the tweet. And then March 18th and 13th, again, more emails about tweets that Jordan Peterson had made about Justin Trudeau and Gerald Butts, his former principal secretary. Anyway, reading through the decision, it's kind of amazing that they took these complaints seriously. But like I said last week, I think somebody well, this is going to conflict with what I'm about to say, but I think somebody at the College of Psychologists is trying to make a name for themselves or trying to make a point here. Although the panel in the panel decision, they black out their names, so we don't even know who the panelists were. Anonymous, 3 panelists. In their decision, it's very broadly worded. They don't really get into the specifics or explain why they think these were problematic, but they say that Peterson poses moderate risks to the public and that comments may undermine public trust in the profession as a whole. So the decision was really mostly just restated the complaints. They say that the Ontario College of Psychologists has standards and identified those standards. And then they opine that that the comments may be inconsistent with the standards, and he may be making degrading and unprofessional comments. So, not very specific, not greatly written decision in my mind. I suspect that if Jordan Peterson follows through on his commitment to take this to judicial review, that he'll be successful when he takes this to an actual court and away from the professional regulatory body. So we'll see what that happens. Those things don't happen particularly quickly, but hopefully sometime in the next few months he'll have an opportunity to be heard in a judicial review situation and be able to put this all behind him. In the meantime, I suspect the fact that he's rejected the college's order to take social media training, that in itself is then going to form the basis of another complaint against him. And who knows, there'll be further sanctions, I suspect, in the meantime. But if this original decision is taken to judicial review and overturned, then all of those consequences should flow back with them and be dismissed as well. So I suspect that'll be the outcome in this matter. I'll be watching it as well to see what else develops. So those are the cases. Like I said, the main one I wanted to talk about this week was this situation, this terrible situation out of Cumberland Regional Health Centre with Elizabeth Smith-McCrossin. Really bad reaction from the Nova Scotia government by taking a legal reaction rather than looking at the substantive issues at the hospital and facing those head on. But we've seen that a few times where people aren't facing the issues head on. That's really maybe a theme with the fisheries case I talked about earlier with the Sebaganagati band, and anyway, with the College of Psychologists with Jordan Peterson as well. So anyway, those are my thoughts for this week. We're in the news, and I'll be back next week with more developments, and I'm sure there'll be much more to discuss. So until then, thank you everybody for watching. Thank you for listening, and we'll see you next time.